If you've been involved in an automobile accident in the state of Pennsylvania in which you believe that you may be partially at fault, you are not entirely precluded or stopped from bringing a claim against the other party. The situation works a little differently than it does in a straight accident where it's clear that the other party's there. In this particular case, the Pennsylvania legislature has adopted the Pennsylvania Comparative Negligence Law, which applies to automobile accidents and other types of negligence cases such as slip and falls or anything of that nature, where somebody has breached the duty of care and injured a party. And the way in which this works is if you end up in court, and let's assume that's where it is, we end up in court and there are two phases. One is the liability phase and one is the damages phase. In the liability phase, what you do is you bring in all the evidence, you bring your testimony in, the other driver or the other party's testimony, any witnesses, and basically you present a case that says, this is the best case for me that says I'm at fault a little bit or a percentage, but the other individual is also at fault. At that point in time, what the jury does, or the fact finder, if it's an arbitration case less than $50,000, they will listen to the evidence and they will make an assessment of percentages between the parties that are at fault. If they think that the plaintiff or the injured party is partially responsible, they will assign a percentage to that individual's responsibility. If the defendants are responsible, they will assign a percentage to them. If there's more than one defendant, they'll break it up between the defendants so that what they do at the end is arrive at a figure of 100%. The fact finder, or the jury, or the arbitration panel will then assess a damages award for your particular injuries. And let's just say that it's a value of $100,000 because it's easy numbers. If the jury has assessed that you are 20% responsible for the accident and the defendants between them are 80%, then what they will do is they will reduce your award from $100,000 by the 20% that you are alleged or found to be at fault. So your net award would be the $80,000 figure. And that's how the juries are assessing. If, however, it gets to the point where the jury has found that you are 51% at fault, then that means that you are the cause of the accident and you now receive no compensation whatsoever, even if the jury has determined that your value is $100,000. If you're 51% or more than 50%, then your compensation will be zero and it'll be found to be a defendant's award and no compensation will be awarded.